What's good, folks? How's everybody doing? So, another day, another bunch of testimony in the George Floyd trial, and the trial of the death of George Floyd, rather, and the prosecution of Derek Chauvin. And today I thought was not a good day for the prosecution at all. I think one of the big issues for the prosecution, I mean, they had something happen that I think will be very, very impactful at closing, and that I think will just give a lot of problems. So, I'm not going to talk too much about the first two witnesses. The first witness was a cardiologist who talked about, kind of reaffirmed the theory put forward by Martin Tobin that Mr. Floyd died of positional asphyxia, loss of oxygen, mostly as a result of being held in the prone position so that he couldn't breathe. And then secondly, I think they had his brother testify. I'm not sure I didn't actually watch that testimony. I didn't think it would be particularly relevant. I think one of the more surprising things about this whole trial has been how much kind of emotional testimony there's been that's just totally irrelevant. Like you mean you're asking questions like, how did George Floyd feel? Like, what did he do in his past? I mean, we're not even close to sentencing. That's the kind of testimony that might be appropriate at sentencing, where you're talking about how profoundly awful the crime that the defendant has been convicted of is, but it's certainly not appropriate at a trial where you're still trying to assess whether or not the defendant is guilty or not. It's emotional testimony. I'm surprised. I think Nelson probably should have objected to it. And, it didn't happen. But the real big, I think, fireworks happened when you had the third witness. So despite the fact that the prosecution has called a use of force expert witness, Mr. Steiger, along with examining a slew of police officers on the question of whether or not Derek Chauvin's use of force was justified, they called yet another witness, who's Seth Stoughton. He's a professor at the University of South Carolina. Let me see if I can find his, information. So here we go. This is Mr. Stoughton. He is an associate professor of law and criminal justice. Oh, that kind of screwed it up. But here you go. Associate professor at the University of South Carolina School of Law, and he is extremely focused on the use of force. I mean, granted, it seems like he's written a lot in the area, but he definitely listening to him and reading. I mean, he's a big lib. He went on, Trevor Noah to talk about proper use of force. This guy, he's a lib. And I mean, I didn't think he was that effective in terms of persuading a jury that might be skeptical of him generally, because, he came off as very academic, not somebody who has been in the field, actually doing police work in a long time, not somebody who had a ton of experience doing police work. So I wasn't that impressive. Oh, is someone mad? I guess someone's mad. Sorry. like, are you mad? Oh, well, stay mad. It's fine. Doesn't mean I'm wrong. But the big problem was that there's a moment where he testified today, and he had a really bad moment. In the course of testifying today, Mr. Stoughton basically said that he thought that at any point, putting the George Floyd in the prone position, that means lying flat on the ground, was an excessive use of force, that's only to be used in a transitory fashion simply to put handcuffs on the person. And after that, they are to be put on their side in the recovery position as a result of the risk of positional asphyxia. The problem is that contradicted earlier expert testimony from Mr. Steiger, who was the Los Angeles Police Department's use of force trainer and the first prosecution expert called on this question, who said that using the prone position was actually justifiable force. That's not good. And kind of to explain why, right? Remember, the big lingering issue in this trial is whether or not Chauvin's use of force was lawful. Because if it is, it doesn't matter if it caused George Floyd's death. He has the right to say, look, I was engaged in a lawful use of force based on the standards that apply to me as a Minneapolis police officer. So basically, that's why the prosecution's calling all these witnesses. They have to prove that beyond a reasonable doubt. If you have multiple prosecution expert witnesses contradicting each other, that's creates reasonable doubt as to whether there even is an agreed standard about what constitutes the reasonable use of force. And especially when it's about a question as central as this one is. I mean, the question about whether it was okay to use the prone position over a prolonged period of time gets to the heart of what actually caused George Floyd's death, right? Like that, the use of force, the medical experts have talked a lot about not how it was the knee on the neck, because it's not clear that Floyd's breathing was really obstructed by like a choke, but rather that by holding and pinning him down to the ground, they were limiting his ability to breathe, right? They were limiting his ability of his lungs to expand, et cetera, et cetera, et cetera. So that problem, that doesn't go away. If they don't agree, if prosecution experts don't agree, there's already reasonable doubt as to whether any unlawful force used by Derek Chauvin is responsible for George Floyd's death, which means acquittal. And so, I mean, that might end up being like a hung jury. I could see that happening for sure as a practical matter. I could see some of the jurors holding out for a guilty verdict and refusing to grapple with the evidence. Hold on, Jack is here. I'm going to literally just answer and be like, I'm live on Periscope right now, dude. If you want to come on.
There is no Periscope anymore. I can't tell when you're live.
He's saying you can't tell when I'm live. Yeah.
No,
well,
I didn't get a notification either.
That's garbage. Oh, maybe they finally got rid of the notifications, huh? That would be really annoying. Anyway, well, throw me a retweet, and if you want to come on, I'll send you a link.
Wait, what? But am I on or?
No, I mean, well, I'm literally holding you like on speaker on while I'm doing a Periscope, so I don't know if they're actually hearing you or not.
About Nelson?
Yeah, we're talking about.
Flip.
Yeah.
The master of the judicial judo flip.
Yeah, exactly right. All right, let me talk to you in a little bit.
Tune in.
All right, peace. So yeah, I think it was that was Jack Posobiec, by the way, if you aren't familiar. But yeah, no, that's a terrible moment for the prosecution, and it's something that you almost never see, right? Like in civil trials, criminal trials, almost always on key issues, the prosecution, the witnesses are in agreement on your own side, and the disagreement happens between prosecution experts and defense experts. What you see here is two prosecution experts saying something completely different. That's catastrophic for a prosecution. It's incredibly disorganized. And it's something that'll create reasonable doubt in the minds of the jury. Like I guarantee you that in the closing arguments, what's going to happen is that defense attorney Nelson's going to get up there and be like, their own use of force experts don't agree on what constitutes reasonable force on a core issue of this trial. You heard one use of force expert tell you that putting people in the prone position is justified and normal and appropriate police policy. And you heard another use of force expert, the random like super lib guy, tell you that you can't do that ever and it's just a transitory position. If they don't agree on that, how on earth are you as a juror going to not have reasonable doubt that Derek Chauvin wasn't obeying the law? And moreover, what is Derek Chauvin, they're just a random police officer, supposed to think? Like, he's got, he's clearly the LAPD's use of force expert, the guy who trains Los Angeles Police Department officials, said this is a justified and reasonable use of force. So that's a really bad circumstance for the prosecution to find itself in, where their own experts are in conflict on a very, very important issue. And it kind of gets to an overarching theme of this trial, which is that there's simply too many chefs in the kitchen and that there's not a good cohesive strategy. There's such a mismatch between a lot of the early testimony. You remember the blood choke guy? I mean, it's almost 2 weeks ago where you had the guy saying, oh, we put him in a blood choke. And then you have all the stuff about the knee on the neck being excessive force. Then you have the medical expert saying, well, the real thing is positional asphyxia from being pinned down to the ground. Yeah, I guess the knee on neck might have, could close some things, but it was the being held on the ground that was the problem. You've got just huge problems in all these different ways. And we haven't heard a single defense witness yet. Like, the prosecution's supposed to end their case tomorrow, and we'll be looking at maybe 3 to 4 days of defense witnesses. And I guarantee you there won't be this problem on the defense side. I guarantee you the defense expert will be singing. There will be one tune that the one book, one theory that the defense experts will sing from, right? One, that Chauvin's use of force was authorized and justified based on Minneapolis policy. And then 2, that there will be a medical expert saying he died of an overdose. Now, unaffiliated mom asked an interesting question. Will Chauvin testify? I think it's an interesting case. Like I generally the answer is almost always no, that you shouldn't have your defendant testify unless they absolutely have to. This is a case where it might be an exception because the facts are not in dispute. So they're not going to get, it's hard to trip them up on like proof that they're lying or proof that they actually committed the crime. Cause you know, we have the video, we know what happened. And so it might be useful to hear about what Chauvin was doing and why at the time. That actually might be really powerful. I don't know. I mean, it'll depend. I wouldn't bet on him being called, but I could see it. I think there's some reasonable chance of that. But that's a very good question. But yeah, so I think that things are, you know, in general, not bad. Somebody points out, you know, the doctor today was so in the can for the prosecution. Yeah, that was pretty obvious. And I mean, you could look at his Twitter. He's just a, you know, wild anti-Trumper. It's not a good look for all these doctors to be volunteering on this case, oddly enough. Like it puts into question whether they're really unbiased. You know, I mean, if you're volunteering your expert testimony, it's probably better if you're being paid, honestly, that like people would say it's more objective. Good question here. What was the decision on Maurice Hall testifying on the stand while pleading the fifth? I think he may end up being called. I think that's the plan. I don't think the motion hearing today was not about whether or not they'll call Maurice Hall to stand. It was about whether two things. One was whether or not they could demand the prosecution explain why they didn't offer him immunity, right? Because if the prosecution offered him immunity, he could testify, no problem. That was denied because the judge said that's an executive decision. There's no judicial review over the executive decision of whether or not to offer immunity. And then the second motion was to introduce a transcript of this interview that Maurice Hall did with FBI officers down in Texas around a month after the arrest. Because the argument being that since he won't testify, he probably won't answer any questions because he'll invoke the fifth. We should be able to, in order to present a complete defense, to introduce the transcript of his prior interview that he did on the subject. The judge denied that motion on hearsay grounds, arguing that there's a hearsay exception called statement against interest, which is you're allowed to, hearsay is bringing in like either a written document or somebody testifying that this other person said this, and that's the evidence, right? That's hearsay evidence. And it's when you're saying that for the truth of the matter asserted, i.e., we have a document that reveals this person saying something and it's being presented to prove that he is in fact telling, that is the truth, and you as the jury should account for these facts as stated. Judge denied that because it didn't fit into a hearsay exception of statement against interest and didn't have the necessary indicia of reliability. So I didn't get an A in evidence, but I think I understood that one pretty well. So who's this? Makes me wonder if the prosecution couldn't get a top class expert to testify in support of their case. Well, this guy is the guy they had today is more of a traditional like expert. He has a lot of, I looked at his CV. He had something like 30 cases in which he had testified, a lot of plaintiff's work. But the problem here is, the thing that I'm blown away by is the failure of the experts to talk to each other, the failure of the prosecution to organize the expert testimony, to recognize that there was this conflict in what their experts were going to say, and then to decide to put on both. Like, what happened? Where was the miscommunication here? Why are I've almost never seen one side's experts disagree with one another, and especially in a case where it's the prosecution in a criminal trial who has to prove the elements of the case beyond a reasonable doubt. If your own experts disagree on core points, you're in real trouble. So that's just really bizarre. It would be bizarre in a civil trial where it's just preponderance of the evidence, but here it's just even more bizarre. So I am very, very confused by the prosecution here. I don't think they've done a particularly good job. So that's I think the problem there. And the other issue with this guy is, he was just a super lib in terms of the way he was answering these questions. I don't think he would have persuaded anybody who didn't already have it out for George Floyd. Just an average citizen, I thought, relative to the other witnesses in the case who have been police officers and, people who've been in the force and do use of force trainings, I thought he came off as a super academic, aggressively talking about what a reasonable officer would do when he hasn't been a police officer for 15 years. I think I was generally unimpressed by him. Somebody asked, like, why isn't this a perfect prosecution? Bad faith? I don't know. Maybe too many chefs in the kitchen. You know, one of the things I think that's helping the defense is it's just Nelson doing the cross, and it's often beneficial. I mean, in any sort of argumentative presentation or argumentative, you know, like a debate, a trial, whatever, if one or two people can really master the whole material and be in command of everything. I mean, sometimes it's too much work, and as a result, you can't do as much motion work. But on the other hand, like, it helps you avoid problems like this, where, you know, one lawyer is working with one expert witness and another lawyer is working with another expert witness, and is not making sure they're not talking enough to make sure that everybody's story is straight. In general, it's not very good. So somebody says, these new riots are surely troublesome for the current jurors. I don't know why not sequestered. I listened to the motion hearing. I understood the judge's position on this one. I don't know but I don't know the law in Minnesota. So, I mean, I'm sure there's like case law on when sequestration is required. But I bought the judge's argument that if you know, they already know that there's some riot possibility because of what happened a year ago. And it's not clear that sequestering them now would make them less concerned about the consequences of a not guilty verdict and less likely to, inappropriately use real world consequences of their verdict and to justify their decision. Like, you know, his point being that, like, well, if you said now that we just have to sequester them and put them away for the next week, maybe they would react to that and think, this is really bad, and so we really need to worry about the consequences. Like, I saw his point there. And also his point being that, like, the reason he was thinking about sequestering was if one of the jurors got outed, right? And if the public was able to identify some of them. And I think that was, that was very good. If Chauvin gets off and outs himself as MAGA, should this movement reject or embrace him? I'd have to hear from him if he testified and maybe justified his behavior more. It's one thing to say the prosecution's proved their case beyond a reasonable doubt. It's another thing to say what Chauvin did was perfectly justified and wonderful. Like, I don't know the answer to that question. And I would be reluctant to just embrace him for no reason without more understanding of what he did. So is the defense a police union lawyer? He's a lawyer retained by the police union. So I'm pretty sure he's a lawyer in private practice. But, I think my understanding is that the police union, part of what union dues go into a legal defense fund that covers that funds the legal defense of any officers who are prosecuted or sued for actions they take while in the line of duty. That's my understanding. So this guy he doesn't work for the police union, as like he's just their lawyer in-house, rather, but he's a private firm lawyer who was retained by the legal defense fund. That's a way to understand that. Don't they have to prove every element of each offense beyond a reasonable doubt? Indeed, they do. That's part of why I've been saying that there's going to be an acquittal. And I don't really think it's that close a case. I think there's going to be an acquittal here. You never know any of this from the mainstream media. Shameless coverage. Agreed. I think the coverage has been really embarrassing from the mainstream media. And I think it's really irresponsible in this case because you're leading your audience on to an outcome that really might not happen here. Everybody refusing to talk about these problems that are being exposed on cross is embarrassing. It's like basically the way that they're doing it is they're only talking about what's happening on the defense side. They're only talking about what's happening on direct examination, rather, and not talking about what's happening on cross. There's a very good piece that I highly recommend on this. First off, Law of Self-Defense has been really good on this, so you should check them out. But I think Shipwreck Crew did a very good piece today that I think you should check out. Derek Chauvin, who actually can do this, so it's a little easier. But the Derek Chauvin murder trial, where it stands after 2 weeks of testimony, highly recommend that you go ahead and read that. That's on Red State. And I mean, he's made a lot of good points just in general. Let's see if I can find his Twitter, because he's been talking about this over the last few minutes. This I thought was a really interesting point from Shipwreck Crew, that Chauvin's attorney did not ask for a mistrial due to the shooting yesterday, and that defense attorneys all look for every opportunity to seek a mistrial when they're losing. Right? I thought that was really interesting. Right? Defense attorneys move for sequestration of the jury. Right? Jury gets put in a motel and doesn't get to talk with the outside world. But they didn't move for a mistrial. I thought that's really, really very interesting. Other things that are interesting. So, I there's one other point that he made. He also, I mean, his whole piece was about the mismatch between the testimony, right? Like you have the medical experts focusing on the fact that he was held down and pinned down to the ground in the prone position, and the use of force experts saying that it was the knee to the neck that was the excessive force. Like, this is actually the first witness who says the prone position itself was unreasonable and excessive force. But that contradicts other experts elsewhere. So I think it's, I think there's reasonable doubt for sure. Let's see, what else do we have in terms of, what about intimidation of the jurors? That's something that I think the judge is worried about. And if the jurors were identified, right now the juror is anonymous. If they were identified, that would be something that might lead to an acquittal. Let's see. Hall taking the stand tomorrow. Indeed he is, but I expect that to be uneventful. I expect him to plead the Fifth Amendment and not answer any questions. And I expect that he will not be forced to answer any questions. So that's what I would expect tomorrow. Maurice Hall might take the stand, but I do not anticipate him having anything to say. That he will take the stand, but not testify. Is a mistrial good or bad? I think basically at this point, from the defense's perspective, I don't think the defense wants a mistrial. I think from their perspective, they've gotten so much value out of cross-examination, and the prosecution's been so disorganized and contradictory that I think from the defense's perspective, if they ran it all over again, the prosecution would do a lot better, right? So I don't think the defense doesn't want a mistrial. I think the defense thinks that they're probably winning, that this is the best chance they've got, and that they're more likely to win this trial than they are to win a future retrial. That would be my assessment. Somebody says, if defense opposes mistrial, new trial likely barred because jeopardy has attached. Well, if there's an acquittal or a conviction, but I'm pretty sure if it's interesting, new trial, is that right? If the defense doesn't want a mistrial, but there's a hung jury, you can't try again. I'm pretty sure you could try again with a hung jury. So yeah. Ben says this is very, very informative. You're welcome. I would do a Breitbart article on that piece, that little contradiction. I think that has not gotten nearly enough play. The fact that you have defense experts contradicting on use of force, and if you actually watch that clip, it is the Nelson explicitly says, so you're saying Steiger is wrong about the prone position, and Stoughton says yes, Steiger is wrong, right? Prone position is absolutely not justified. So, oh, you're no longer with Breitbart. I didn't know that. I'm sorry, Ben. I don't know where you are now. If you guys are enjoying this, hit that. If you're on Facebook, hit the like button. Now we'll do the promo, since I'm getting a whole bunch of comments that are like, you're doing a great job. So, okay, now here's where I make the pitch. Hit subscribe if you're at youtube.com/humanevents. That gets you access to the live streams. Hit like on Facebook. That also will get you, I think that will get you access. I don't know, but you should like our page for Human Events. And then on Periscope, or on Twitter rather.
I found this on the web.
What the hell? I thank you, Siri. I don't care. So go on Twitter, and again, if you're looking for how to follow my live streams on Twitter, here's what you do. Okay, you go on your mobile app, not your desktop app, your mobile app. Thank you, Twitter, for making this so hard. You see that little button with the notifications next to following. You hit that, and then it'll pop up and say only tweets with live video all the way above. You see that? Only tweets with live video. You hit that, boom, and then you're in, and you go. And this is not. Don't go to Jack's profile, although you should probably follow his live streams as well. But go to my profile, Will Chamberlain, and do that, and that will get you access to the live streams if you are enjoying them and want to continue to get them. Ooh, El American, a new outlet aimed at Hispanic conservatives. Well, if you want to do El American, write something up for El American on this. I think this is an obvious thing to write about. So, yeah, it's a very, very interesting trial. I agree, and it's an interesting trial because it touches on. It's like you're getting to see a lot of interesting debates happening, and it's really, even though you haven't seen the defense experts yet, but there's a lot of really interesting questions about. There's an open question about how he died. There's an open question about proper police use of force. There's been a few boring witnesses, but the sort of the expert testimony I think has been really interesting. And I don't know. There's ways in which the law can be really fascinating. I think I was talking to apparently Jack's wife Tanya is fascinated by the trial and is watching it all the time. I think it's really good, entertaining. Let's see here. Any other questions? Right, like somebody says, where I'm trying to click it. Yeah, did you just supply fentanyl to George Floyd in the SUV? I plead the fifth. Right, he's not going to answer any questions. So anyway, I've got a steak dinner coming. That's what I got for you. Thanks for watching. Hope you enjoyed it, and keep following the trial. There's going to be more updates over the course of the week, and I intend to continue to provide this to you guys. So thanks so much. I'll talk to you later.